Have you noticed how aggressively the Trump administration is trying to deport people right now? These days, the government will do almost anything it can to deport someone. And one of the ways they're doing it is by framing immigration cases around allegations of terrorism. That doesn't necessarily mean that the person involved is a terrorist. In fact, quite the opposite. Under U.S. immigration law, there is a broad and deeply misunderstood category called a Tier 3 terrorist organization. The government can slap that label on almost any group involved in a conflict overseas. In fact, by definition, a Tier 3 terrorist organization is one that has not been designated as a terrorist organization by any other agency of the U.S. government. It is a catch-all, and that is the way that the Trump administration is using it. In some instances, the Tier 3 terrorist label is even being slapped on people who are completely aligned with U.S. interests. Because these definitions are so broad, people can face serious immigration consequences just because of their political opinions and because of their associations back home. And once the word terrorism appears in your immigration case, you are fighting an uphill battle. You can be detained and you can be deported. If there is any allegation of terrorism in your immigration case, or if you are a political dissident who has dared to speak truth to power, you need legal counsel that understands both immigration law and national security law. And that is exactly what we do at Charles International Law. I am Nathan Charles, the founder and managing partner of Charles International Law. I have over 25 years of counterterrorism experience as a U.S. Navy SEAL officer and as a federal prosecutor in the National Security Division of the U.S. Department of Justice. When the government uses the word terrorism, your case is no longer routine, and your attorney shouldn't be either.